And we're going to continue off. If you're just joining us, we are reviewing a book called Cracking the Code. Now, Cracking the Code is a book that came out like 2001, and it was a book. Let me give you a little backstory on it. You know, a friend of mine had this book, and he brought it to me, and he said, man, if you learn this book, you'll be a bad motherfucker. And I looked at it, and I said, I went through it. I said, man, is this some law or something? And he said, yeah. And I said, man, I ain't got time for that. I handed it back to him. And then, of course, later on, I ended up having to ask him, hey, man, you know that book you tried to give me? You still got it. It was one of those type of situations. And chapter 10 has always been dear to me because I was locked up and somebody passed this to me. I don't know how I got a copy of it. But that was the only chapter I had gotten a copy of was chapter 10. I didn't have the rest of the book. They make it real hard for you to get the book in there, but I didn't have the book, but I had chapter 10. But by the time I got a hold of chapter 10, I had access to a law library, and I had already pretty thoroughly familiarized myself with these subjects. I understood what a UCC1 was for. I understood I taught myself how to do my UCC1 filings out of a book called One Man Out. We're going to go through that too, a book called One Man Out. But it was a hodgepodge. I got my education from disparate sources and a different eclectic selection of all type of individuals, but one thing that I came to know is that they were all talking about the same thing, but they were just expressing it in different ways. And I think my background in comparative religious studies helped me to see that too. A lot of people, they concentrate on the differences. I don't concentrate on the differences. I concentrate on the similarities. Because once I concentrate on the similarities, that's the pathway to truth. That is my way of coming into an understanding of how I can make this information my own. I can put it in my own words because I see how everybody else is putting it in their own words, So I've been sharing your video like crazy, and nobody wants to put in the time to even look for the answers. And hey, they got to keep paying. See, that's why people charge. Those are people that got to keep paying. They got to keep jumping from guru to guru, talking about this process and that process. They the ones that got to keep spending their money. Don't feel bad about it. Let them keep complaining. Let them spend their money. Let them do things like that. I'm on right now on YouTube for free. I'm supposed to be doing this at SBC University. I'm right here on doing this for free on YouTube because I want people to see I'm not playing with it, and then also for you, there's a lot to know. There's a lot to learn. This is just a small little piece of information. And then I had someone in the comments section had the audacity to say, show some proof. And it's like, these are private processes. If I come and show you, and these are the individuals, they're not very intelligent. They think they're intelligent by saying, show me some proof, but they're not very intelligent at all. Because if I was to show you that my car got discharged, how would you know how I got discharged? If I bring you the title to my car, and then I just show you a copy of a process I use. I show you, okay, here's the certified mail letters and everything. This is what I sent out, and here is my my title to my car. They don't send a letter saying, thank you for your payment. Thank you for sending me your bill of exchange. They don't say that shit. When they dismiss a case, they don't say, you know what, you're right, you're a sovereign. And you're absolutely correct. This is civil. We're going to dismiss the case. These people they fools. They fools and demons because they think when they say that, then in some kind of way, there's a reason this information keeps going for 50 years. I didn't make none of this shit up, man. I didn't make none of this up. I didn't make none of this up. There's not nothing that I'm talking to anyone. That's why I don't write a book. I pull stuff from other books and show you there's nothing in any of this that I created. It's been around forever. I just studied it for a long time. I just feel like I'm very well learned in the subject. But I didn't create any of this. It's been around. This was around before Gene Keating. It's been around for a long time. These dudes, man. And if I met someone in Philadelphia. He showed me his UCC1 he filed in 1968. They looked a lot different then, a lot different. I think it was 68. Don't quote me on that, but it was old. It was an old UCC1. And I asked him, and here's it. Y'all gonna get mad at me again. I asked him, where did he learn it? And he said some Jews taught him. And this is an old brother. He said some Jews taught me. Thank you, Master Teacher Yusufel, for sharing your knowledge for free. I appreciate you. Thank you, the Greek surgeon. I really appreciate that. Tamara Allen, I appreciate the $5. Thank you so much. Go do you. I appreciate the $9.99. Go do you. I appreciate that. Thank you so much. And all the people that I missed, who I meant because you kind of went off the screen, but I appreciate the donations. I really, really, really do. I appreciate the donations. And those will be the questions that I'm going to be answering in the chat, the people who donate. You know, if I see a big color pop up on the screen, those are the questions I'm going to answer if you have a question. All right. So without further ado, all right, let me see where we at. We had 100 likes. Yeah, I think we had 100 likes. Yeah, we good to go then. We ready to go. So let's get to it. So yesterday, oh man, did that go to where did it go? What is this right here? This is something. Oh. Okay, here it is. Unlocked. All right, y'all, hold on for a second. Okay, let's get into this. All right. So we are talking about an administrative process right now. Now, cracking the code deals with common law copywriting the name. That's what it deals with. And it's not that I'm trying to teach you how to common law copyright your name. That is not the point of me doing this at all. What I'm trying to basically point out is different salient characteristics of administrative processes that you're going to have in every administrative process that you do, no matter what it is. This is very good, though. It's very involved, and it's sophisticated. But it's gonna have some information in it that's just gonna stick with you, no matter where you go, no matter what you do, no matter what process you finally land on. There are going to be some things in this that are going to stick with you for a long time. So right now, we are talking about selecting the correct party to receive your written communication, because obviously a person is using your name. Maybe it's some sort of debt collector or something that has your all caps name. He's attempting to get money from you in some kind of way. And so he has a claim against your estate, and you think it's a fraudulent claim, or you're asking him to provide proof of claim. And so yesterday we talked about the Fair Debt Collection Practices Act, of how for a debt to be valid, it needs to be verified. And so now we're going to see, once we get all that information together, we put together a contract. All this is kind of like steps two when you're getting ready to put a lien on someone. These are some of the steps you need to take, proper notice requirements and things like that. All right, so we're going to talk now on who to submit the paperwork to. Who is it that we're supposed to be giving all of this paperwork to? Who are we supposed to be giving all this paperwork to? So right here, it's going to say selecting the correct party to receive your written communication. Computer printouts. We do not recommend corresponding with computers, but it is important to respond. If you get a computer-generated presentment, call up the sender organization, feign a cooperative attitude, and find someone who will either admit that he or she sent you the computer printout or will issue another with his or her name on it. If you have no name, use the senior executive of the organization. Hopefully you will not see many of these. Now, these are these computer, you probably have gotten a letter from a debt collector, and there's nobody's signature on it, okay? It's just a computer printout. It has no basis in law. It don't have no legal effect to anything like that. There's not even any proof that they sent it to you. There's nobody at his company that wants to take liability for sending you that correspondence. What you are seeking at, and this is what's going to happen too, when you start hitting them with the right correspondence, they're going to start having people from their legal department or something like that with a name or somebody like that write back to you. But right now, if you get a computer boilerplate, computer generated document, they not taking you serious and they're not serious about it. They just shooting something out there, hoping to get some sort of reaction from you, and hopefully it will be the type of reaction that will put some money into their pocket. But when we see things like that, we're going to laugh at it. That's, they playing. Okay, so that's what he's speaking of right here. He's saying call the company up, feign a cooperative attitude, see who the liable person is, see what department is the one that issues those letters, and then put their name on it. And if you can't find anyone, there's always the CEO. Don't never be afraid to write the CEO. I don't give a fuck about a CVO. I don't care if it's Mark Zuckerberg or goddamn Facebook. So what? I got a company. I'm a CEO too. He just made more money than me. That's all. He ain't got no higher status than me or anything like that. I'll write his ass a letter too. I will write Jamie Dimon of Chase Bank a letter too. Hey, Jamie, some of your people fucking up. Hey, you know what? This never shouldn't even got any, and this is what I tell employees too. Like say, for instance, I'm like I called T-Mobile one time and I had taken a cruise. And so I've been using my phone while I did see, and I got my bill. My bill was like, they had charged me for every phone call. My bill, I think, was like $1,500 or something like that. Never to say, it threw me off because it was unexpected. And so I called up T-Mobile. I said, say, man, what is this, man? So I got into an argument. I wanted them to take the charges off. And they were talking about they weren't going to take the charges off. So I told her, I said, look, let me tell you something. I will sue T-Mobile. And I said, I don't even care if I lose because it's going to only cost me $300 for the filing fee. You're going to have to have to get some attorneys, and you're going to have to respond to my lawsuit. And I'm going to hail. Hold on for a second, y'all. Okay, sorry about that. Somebody was at my door. Okay, now back what I was saying, yeah. So, it's T-Mobile employee, she didn't want to take these charges off my bill. So I say, look, I will sue T-Mobile. And I said, I don't even care if I don't win because I'm going to hail your CEO into court and you're going to have to explain to him why this bullshit got on his desk and why you couldn't take care of it. So I'm always, and I kept going. They took it off. They took everything off. Now you can leverage other things like how long you've been with the company, if you've been a loyal subscriber, like things like that too. But there is something to say. It's like the CEO of they don't want some things don't need to hit their desk, but they are the person that can bind the corporation. So if you can't find the name of an individual, put their name on it. Go to the Secretary of State's website and look it up. Research it and find out who is the person liable. All right. So, okay, cool. All right, so let's keep going. So if you get those boilerplate, like a debt collector send you something, hey, this is the debt collector, we're collecting the debt, and ain't no signature on it, they not serious. They're not serious. We need to talk with who is liable. We're always looking for liability. Who is the person who's liable? Who wrote me this bullshit? I need a name. And they got some very, very good things I still use to this day when dealing with debt collectors. When debt collectors call my phone, they don't like calling my phone. It's almost like they all in the database know when you call this dude right here, he hard to deal with, because they call me on the, I don't never say, they say, yes, I speak with Mr. Jones. And I say, who is this? I don't ever say, this is he. When somebody calls you and you don't know who they are and they just first ask for your name without identifying who they are, make them identify themselves. You don't say, this is me. You don't ever say that. You make them identify. And if they can't identify who they are and where they're from, then they are a debt collector. And you let them know, look, you're right now, if you call back this number, it's going to be $1,000 for every contact according to the Fair Debt Collection Practices Act at 15 USC 1692G. I'm herein demanding that you stop contacting me on my phone and that you correspond with me. And then they keep trying to talk to me. I say, I'm sorry, can I get your social security number? I start asking them for personal information because I need to know who I need to hail in the court. Because I already told, now you ain't abiding by the law, so now you must be doing your own thing. So now you must be wanting to take personal liability for this. So I need to know who you are on the phone. And sometimes they'll be very, very aggressive. I get a black woman to call me and everything. I just love it but I even love it more. If I get through slapping her around for a little while on the phone, it's like they think they'll call me, be with the aggressive. I love getting calls from debt collectors. I love getting called. That is the best time you can practice what we're doing in here. You let them call you up and just practice on them. Just practice on them because they don't have no standing to collect the debt in the first place. So let's look right here. Notice by written communication / security agreement, it is recommended that you send out at least 2 of these when you receive a presentment demanding acceptance of responsibility for payment at a later date or responsibility for specific performance. A, one for the agent, unauthorized user, who put his or her name or signature, same thing as UCC 3401 on the presentment, and one for the agent's principal. So it'd be like, if there's an employee, the employee's name and the CEO's name. Because, notice the agent is notice the principal is notice the agent. The employing organization, law firm, government agency, bank, etc. This puts them on notice that any additional use of your private property by any of their agents automatically executes a consensual contract and obligates them for each use from the beginning. Then you go, okay, you have a validation of debt package. Now you're going to see a lot of these floating around on the internet, just all over the place. People have been writing up different ones for ages, and people pull things from different sources and hodgepodge and piecemeal things together and create their own documents. You're going to just see a lot of that over the internet. A lot of it is okay, but I've been looking at so many of them. I prefer to write my own. And that's where I want you to get to. I want you to get to the point where you write your own. All right, so proper package. This pack. Somebody said. I filed, my license was going to be suspended. Okay, yeah. I went to the court where they filed, which was not the county I lived in, and found that they were on the address I lived in. Okay, what are we talking about? A driver's license? Because listen, you can't do this with benefits and privileges, man. If it's a benefit and a privilege, you ain't in the control seat. If they want to suspend your license, ain't nothing you can do about that. That's their stuff. It's their property. You can't make them do something with their property. The court did not let me file because they said I had to also pay the default until the judge decided who would get the money. I don't know what all that is because I ain't never had a clerk ever tell me I couldn't file paperwork. I ain't never had a clerk tell me that. Because when you go up to the clerk's office, they just sitting there at the counter. You just hand them the document with the case. Now, if everything looked the way it's supposed to look, they file it, stamp it, give you a copy of it, and move on. I have never in my life had a clerk tell me I can't file something. I've never had that happen to me in my life. I've never had a clerk tell me I can't file because I know how to make my paperwork look. I know how to present it. If a clerk did not file your paperwork, or if you have a filing fee or something like that, they cannot if they requesting a filing fee. Can you finish the case ex parte Milligan? I didn't start no case ex parte Milligan. I haven't started a case ex parte Milligan. And I'm talking about this right now. So if you don't want to listen to this right now, you may want to come back in about 2 weeks because that's how long I'm going to be talking about this right now. I don't want to talk about no ex parte Milligan. That shit don't have nothing. That's not teaching me. That doesn't contain the wealth of information that I'm giving you right now. I don't need to be talking about no ex parte Milligan. I'm not going to talk about it right now. You know, what's wrong with y'all, man? Don't y'all see I'm doing something right now? I have to go in on y'all because that's rude. We're talking about this. What, you don't find this interesting? That's why y'all be fucking up, because y'all ain't got no fundamentals. Listen, I've been doing this. Oh, let me put the camera on me real quick. Let me put the camera on me, man. Let me put the camera on me. Let me tell y'all something. I've been doing this for 20 years. I have a Facebook group with 25,000 people. And I can tell you right now, 99% of the people don't know what the fuck they're doing. Including all y'all in here, right here, you're talking about want to talk with Milligan and things like that. 99% don't know what the fuck you're doing. You want to talk about a case, you don't even know it's probably civil procedure or criminal procedure or nothing like that. And you want to talk, you probably don't even know how to read a case citation when you can look on the internet and figure it out. That should be one of the first things you should learn how to do, is how to go to a law library and find the books just like when you go to the regular library. Things like that. 90% of the people can't read a case citation. Probably 95, 97% of the laymen, they can't read one. But they want me to do all this other stuff, and you ain't got basic stuff down. That's why I started a school, because I could have just did what everybody else was doing. Say, look, I'm selling this process. It's $2,500. You want to buy it? And then sell it to you, and then just, you never be able to contact me again or whatever, like a lot of those gurus do y'all ass and shit like that, But no, I don't want to do that. I'm taking an effort. But we live in an age where people don't want to learn. You don't want to learn. And then you want to complain because people charge for things. Dudes are mad at me right now because I charge $49, even though I come on YouTube and do shit like this all the time. They only mad because they say he making money. Look at this nigga. Look at him. He got a Robert Graham shirt on. He got some $1,000 Balmain lenses with frames with some $600 progressive lenses in them that are tinted. I don't like that shit. I just don't like it, But it is what it is. So y'all gonna keep paying and do things like that. I'm gonna keep trying to teach you. I'm going to keep trying to teach you. These are basic. This is basic fundamental stuff. A lot of people don't know this. And believe me, a lot of the stuff I'm saying does stick with people, you know. But anyway, let's keep going. You can get rich in the law library. I see people talking about the law library. You can get rich in the law library. There are things in the law library that can make you a lot of money. And regular books you can find, like, damn, you could take it and sell it. And especially in these spaces that we're in right now. All right, so let's keep going. There's a lot of studying. Listen, man, I read every day. I was in jail though, but I read every day. I'd get up in the morning about 6 o'clock. The first thing I would read would be The Master Key by Charles N. L. I'd read one of those lessons. And then I'd either pull out creditors and their bonds or dealing with presentments, and I'd read the entire document, all 52 pages, 53 pages. Every time I read creditors and their bonds, I'd read the whole thing from beginning to end every day. So I read it probably 300-400 times, you know. Then I'd read, you know, that's why you could just open up that document, go anywhere, and I could talk an hour on every part of it. So, you know, that's what I'm doing with you. I'm showing you what you need to know, because all this information, there is no formal source for all of this information we're studying. What you're looking at is the intelligence of a lot of highly intelligent people who've done the research and have come and put stuff in documents and things like that for you. But there's no formal source for all of this information. There's no one point of origin. So at some point, with that in mind, you need to understand that you need to learn how to make your own documents. And the only way you're going to learn how to make your own documents is when you learn all there is to know. That's why I'm going through this right now. And you know what? I pay attention to the numbers. Like I watched the numbers for cracking the code. Like the first one is a lot of numbers. And then the second one, probably not as many people tuning in, because people have a very short attention span. But in this space right here, you can't go for high numbers. You got to go for quality, because it's only gonna be a few people that you're going to really, really touch. The majority of the people are going to be kind of like weekend warriors, or they just passively listen. Some things stick with them and things like that. And for the person that sincerely is in need of something, maybe they got a criminal case coming, or, you know, children got taken, or, you know, they got a DUI, whatever, you know, they probably gonna pay a little bit more attention too. And that's just how this information is. I'm not mad at people like that, because that's how I was. When they first came to me, I didn't have any trouble. So when they presented me with the information, I pushed it to the side. It wasn't until I had a problem I started paying attention. And that's unfortunate. People do that. And I'm trying to tell you, don't let that happen to you like it happened to me. Don't wait for something to happen to learn this information. Start learning it right now. All right, so let's get back. So number 2. Validation. Number 3, validation of debt package, the administrative remedy demand. Used when someone is demanding payment of you for a loan of credit or an unsubstantiated debt of some type, such as payment of taxes, as long as you have not already inadvertently validated the debt by swearing that you owe it. Maybe you filled out some tax forms saying you owe it. All right, so where's the proper usage? This package will not work when a creditor has given you substance in exchange for your promise to pay. Only credit. And that's going to be a note about like people who have buy here, pay here cars. When you buy from a buy here, pay here, you can't use that with a buy here, pay here. An example of this is buying a used car from a dealer who does not use an outside creditor but carries the paper himself. He can validate the debt because he personally gave you substance. And these are people you'll see, they'll take you to court and try to get you arrested too. If the same dealer were to obtain financing from you from a credit lender and the credit lender attempted strict foreclosure, it would eventually lose because the lender incurred no risk of loss in the transaction. only the loss of anticipated gain, invalid claim. So that's what most of these people, when you go out and buy a car, the only thing they're losing is the loss of anticipated gain. They don't have no substance. They don't have no skin in the game. So this is one of the most important parts. Now, this is one of these parts right here that's going to be worth the whole class today, because you have a whole bunch of people out there trying to discharge cars, and some of them get their cars taken or they don't understand what's going on. When I read this right here, I can't tell you how real this paragraph right here is. It says an important note on auto loans. Auto loans are issued with the proviso that the lender can take the car, strict foreclosure, if you fail to make the payments as agreed. If you look at your auto loan, they got what's called confessed judgment. Confessed judgment. Confession of judgment. All right. This is in every car contract, new car contract that you got. This is why they can come and pick up your car without taking you to court. A confession of judgment is a legal device, usually a clause within a contract in which a debtor agrees to allow a creditor, upon the non-occurrence of a payment, to obtain a judgment against the debtor, often without advance notice or hearing. These clauses may also require the debtor to waive their right to assert any defense against the entry of judgment or be represented by an attorney appointed by the creditor. Confessions of judgment tend to be controversial and are frequently challenged on the grounds that they facilitate predatory lending practices or violate due process rights. But nevertheless, they are in all the car contracts. So you need to be aware of that. In every car contract, you're going to see that. It's called confessed judgment. Confessed judgment. Thank you, Jeremy Pollack. Appreciate that. And also thank you, Just Be You, $9.99 for all the knowledge you can give. I appreciate it, bro. So understand that, and confess judgment. When you try to discharge these cars, this is a tricky situation. All right, so let's get back. Understand what a confessed judgment is. If you got a car contract, you got access to yours, look at it. You're also going to see on there, let me tell you something else while we're talking about a car. On your car contract, it's going to have something called claims and defense notice. And it's called the holder in due course clause, and it's put out by the Federal Trade Commission. It's called holder in due course rule. Now, this is something that's very, very important. Holder in due course rule prohibits a seller from taking or receiving consumer credit contract that does not contain a prescribed notice which preserves the consumer's claims and defenses in the event that the contract is negotiated or assigned to a third-party creditor. Now, this is the claims and defense notice is not a notice for you. They put that in car contracts too. They're supposed to put it in mortgages, but they don't. And what that is that is a notice to let whoever purchased that contract know that there are certain rights that you have retained. And one of the main rights that you've retained is the right of set off. This is a very, very important thing for you to understand. This holder in due course rule. You need to research this so you get an understanding on it yourself. It's called the holder in due course rule. You are the holder in due course because you are the source of the credit, but you got to learn how to make a claim on your instrument. And that's why you have a UCC 3-306 and UCC 3-305. I'm going to take a little time today and talk about the holder in due course because that's something that all of you have to understand, especially if you're doing this. All right? So let's get back. So auto loans are issued with the proviso that the lender can take the car, strict foreclosure, if you fail to make payments as agreed. However, if they cannot find the car, they have no way to enforce this clause. They can only sue for the balance plus costs and attorney fees. Let me tell you something else. If you come out and somebody is hooking your car up to a truck, just get in the car. Just get in the car. I see so many people, they want to argue with the tow truck person. Just get in the car. They have to put the car down on the ground. They cannot move the car with you in the car. Then call the police. When the police comes, he can't do anything. He is only there to ensure there's no breach of the peace, meaning nobody gets into a fight or nobody tries to forcibly do something, because this is a civil matter. Eventually, he will leave. He will put the car down and will leave. It might take 30 minutes because he has to go and do some other business. But you know, if you come out and somebody's hooking your car up, jump in the car. Okay? And don't let the police talk you out of the car, because sometimes a dirty ass police officer, when you know you ought to get out the car, just, man, look, man, I'm not doing nothing, man. Just understand the police can't do nothing. He's there as a witness to ensure that nothing happened. There's no breach of the peace. So understand, if your car is getting repossessed, don't ever just stand there and let somebody hook your car up to somewhere. Just get in the car. Then take the car to a storage facility. Pay for storage and have it locked in the storage until you figure out what you're going to do with it. Pay the $300 or $400 for the storage. It's a civil matter. No, if they repo the car and they didn't breach the peace, meaning they went in going in your garage is a breach of the peace. They can't go in your garage. Or going into a storage that you got locked. They can't do that. However, if they get the car without a breach of the peace, you're going to have to get it back. And probably the fastest way you can get it back is by filing bankruptcy. You can file bankruptcy and then tell the court that you need your car to go to work. And you have to do it within 10 days. Y'all can get on the internet and Google what I'm saying right now. Get your car. As a matter of fact, let me just do that for you. In order to get your car back, right here, see right here? Where is it at? Bankruptcy in your car. For many people, their car is the most important asset. Without a car, it can be difficult to make it to and from work, school, or the doctor's office. Because it is so important to have transportation, it can be stressful if you're at a point where you start falling behind on your payments. Many Georgia consumers are surprised to learn that there is no grace period for car payments before the lender can repossess the car. There's not. You miss one payment, they can come get it because there's because of that clause that's in there. A payment that is a day late or $1 short is sufficient to put the loan in default and give the lender the right to repossess. Once your car has been repossessed, it can be expensive to get it back. Sometimes, if you're facing difficulties with your car payments, a bankruptcy petition may offer some relief to avoid repossession or even undo a recent one. And I don't want to read all this, but he says, in order to get your car back from a repossession called a turnover, the repossession must have occurred within 90 days of the bankruptcy filing, and you will need to make adequate protection payments to the lender until the court finalizes your Chapter 13 payment plan. And I'm trying to see, can the repossessed car stop car repossession? I want to see when you get it back. Can bankruptcy help me get my car back? Yeah. If your car was repossessed, filing bankruptcy may help you get it back, but you need to act fast. If the lender has already sold your vehicle at auction, you won't be able to get it back. Even if you can use bankruptcy to help you get the car back, you want to carefully weigh your options. If you can afford to keep making your monthly car payments, it may not make sense to file bankruptcy just to get your car back, because you can end up in the same situation again. But you can get it back, like I'm saying. Just get with an attorney or somebody like that and just tell them, hey, my car got repossessed. I'd like to get it back. And if long as you do it within 10 days, you should. Because the reason it's 10 days, because once they repossess a car, they auction it off within that 10 days. You can file whatever federal claim you want to. Don't matter. See how at least people in the comment section talking about filing federal claims and shit like that. When it's talking about with a car is by possession. Who have that title? Whoever has that car in their possession, that's why it's called repossession. We in possession of the vehicle. Who have the title? Cars don't work like houses. Y'all better understand that. Cars about who have possession of it and a title. All that federal claim shit, you wasting your time. They're going to sell that motherfucker and you're going to be trying to do a federal claim. It's going to be gone. That's why it's smart too that if you discharge a car, if they accidentally send you the title, to go ahead and sell the car and then go buy you another car. Go sell the car and go buy another one. Because they're going to do that to you. What's good for the goose is good for the gander. It's a mean game when it comes with them cars. Y'all just don't understand. That's why right here, this chapter right here is a very, very good chapter. A very, very good chapter for you to understand. Appreciate the $19.99. Just learned how to look for case laws at the law library this week. Haha. I really thought it was one book case law. That's great. That's fantastic. All right. So, however, if they cannot find the car, they have no way to enforce this clause. They can only sue for the balance plus costs and attorney fees. For this reason, it is a good idea to keep the car safely tucked away in an entirely different location until the matter is concluded, because they will swipe the car if given half a chance, thus forcing you to go through their tag team partners down at the local courthouse if you want to get the car back without forking over Federal Reserve notes. And that is exactly what's going to happen. If y'all don't learn nothing else today, all right, you better memorize, because I get so many people coming talking to me about these cars when they try to discharge a debt. And I say, did you even read? This is what I mean when I say, did you even read any of these documents? But nobody reads anything. And right here, it tells you, you're trying to discharge. Let me tell you something. You don't even have to be behind on your car payments. Just you sending them a negotiable instrument, telling them that this is for full satisfaction of the loan, they come pick up your car then. Because all they have to do is say that they feel like the collateral is in jeopardy, and they'll come pick it up then. I'm telling you, y'all don't play. If you're gonna, my advice in discharging the car, always lock it up. You recover it because you got to send out a B-10 proof of claim form to all the creditors. You got to let them know you filed bankruptcy. They're going to put an automatic stay on it and bring them into court. You get it back when you're in court. What you mean how you get it back? I just told you, you got to tell the court you need your car for your job. The court is going to order them to give it back. How else are you going to get it back? So, Pounder, they took it before the trial date and already sold it by the time the case was over. If you respond to their notice of foreclosure with a notice of settle of cure, can you create an estoppel? No, you can't stop them from doing anything. You gotta listen. You gotta stand out there. It's war. If the only person that can stop them from doing anything is the court. You can't stop nobody from doing shit. You know why? Because the enforcement arm is the sheriff, and the sheriff is going to follow a court order. He don't give a fuck about all this paperwork y'all have talking about estoppels and all that shit. You got to, all roads lead to court. So if you're going to get an estoppel, it's going to be a court order. Nobody, you out in the wild, wild west, ain't nobody just stopping because you sent them a piece of paper. They can, even if you file bankruptcy, they can still proceed with the foreclosure. They just can't foreclose, but they can keep doing the process and the paperwork and all of that. So when there's when there's a release of automatic stay, they can just move forward. Any info as far as being arrested for bullshit traffic? Well, maybe when we read this, you'll have an answer for your question, Night Owl. All right, let's get back to this. All right, so B, you are current on your payments but want to terminate the loan anyway. In this circumstance, you can call in and ask for a payoff. This is important. This is going to also fulfill the requirements under UCC 3-611 with accord and satisfaction. All right, you need to always get a payoff. You ask for a payoff. That's going to computate the principal and interest. You ask for a 30-day payoff, whether it's going to be for a car or whether it's going to be for a home. You ask for a 30-day payoff before you discharge something. All right. Messed up. So written notification of a payoff balance does not constitute a presentment, not a demand, but can be used to ascertain correct dollar figure. Request a payoff balance that is good until a certain date, 2 or 3 weeks. I always ask for a 30-day payoff from the date requested. Inform the agent that you need the balance in writing, not verbally. Well, nowadays they provide you with a payoff. If you go in the back if you're making payments online, they usually have something you can download it. They already have it pre-computated out for you. You know, there's some, but just make sure you get a payoff. And you need someone to verify the figure because you do not want them coming back afterwards and saying, oh, there is this other charge we forgot to mention. The reason you need a payoff because you're doing a set off and you have to have the exact amount. You can't have set off something and you give them something more than what is owed or less than what is owed. You have to know exactly to the penny what is the amount because we're setting it off. Oh, okay. Just tell them you need written verification by a responsible party that the payoff balance is accurate. They should have no problem complying. Correct recipient for sending in the payoff balance. Even though you have a verified payoff balance, it is very likely that the sender will be unfamiliar with the certified promissory note. However, there is another officer that is well acquainted with the significance of such, head of the collection department. For this reason, it is not a bad idea to send your package to the head of the collection department. Since payoff balance is not a presentment, reword mentions of presentment to written communication. All right, so right there is telling you don't use the word presentment, use written communication, and send it to the head. They tell you where to send it. Send it to the head of the collection department. All right, what do we do if we behind on payments and there's threats of a foreclosure? Even in extreme circumstances, credit lenders like to refrain from sending out actual presentments. They especially like to withhold the name of the agent sending the correspondence, instead using the name of the principal, the name of organization, a generality, a department within it, etc., instead of that of a flesh and blood man or woman. The purpose is to get you into the 11th hour and then bring in a government agent, namely an attorney, to finish you off. See Section 2. And you'd be surprised how many people foreclose on people and they got little mom and pop corporations and you think it's a big corporation. The Fox Guard, okay, so the Truth About Esquire segment entitled The Fox Guards the Hen House for proof of an attorney government agent status. Use the first presentment you can get your hands on and request that they validate the debt. All collection activity must cease. Now, this is another reason why you're using the Fair Debt Collection Practices Act, because when you send that to them certified mail with an affidavit of mailing, they got to cease and desist all collection activities. Now, what they will usually do is immediately send you some boilerplate documents with nobody's name on it or copies of stuff that you can go down to the courthouse and get, like a copy of your mortgage and then a computer printout of some payments. That is not a verification of debt. A verification of debt is something that is attested to under penalty of perjury. This is why yesterday, when we were talking about Tom Schaaf's, the Banker's Secret Manual, in his package, he sends the CEO or the CFO of that corporation a affidavit. If they're saying that they owe you some money, somebody has to swear to something or it's not verified. That is all you're looking for. And they're not going to do that. That is when you're going to see the fraud. That is when you're going to see they're going to keep trying to press forward and foreclose or take your car or do whatever. That is when you're going to learn that these people are corrupt. I don't care if you're a banker looking at me, listening to me right now. I don't care if you're an attorney listening to me right now. This is the point that shows that you a devil, that you a demon, that you is a liar, and all of the other shit that y'all like to talk about sovereign citizens. I'm hearing right now saying that you are a piece of shit because you know all debts have to be sworn to. So use the first presentment you can get your hands on and request that they validate the debt. All collection activity must cease, at least according to the Fair Debt Collection Practices Act, until said validation is provided. However, shyster judges and attorneys do not like being told that they can no longer pillage and plunder as they have been doing for their entire career and may try other tactics to get you to trip up. Keep putting their nose back into the validation, and that is exactly right. That's why I'm always talking about the Constitution. They don't like the Constitution. That's why I keep putting, anytime you hear me say the Constitution, what do I say? Yeah, the Constitution for the United States of America. I always say the whole word because it's like putting your nails across the chalkboard. It just does something to ghost, and demons, it's like the Constitution for the United He said the Constitution for the United States of America. They hate that shit. They talk about this document all on television and everything. You bring it up in their face. Look at their face when you bring up the Constitution. Look at their face when you call them a public servant. That's how you're going to find out who you're dealing with. They hate it, boy. Just test what I'm saying. They hate it when you say, according to the Constitution for the United States of America, in Article 1, Section 8, Clause 17, it is my understanding. And then when you get through saying whatever you're going to say, you always end it with, wouldn't you agree? Wouldn't you agree with that, sir? Wouldn't you agree, sir, that I have a constitutionally protected right to know the nature and cause of this action? Wouldn't you agree with that statement, sir? No, they got to say yes or no, No, well, why wouldn't you agree with that, sir? You saying I don't have a constitutional right? Like when they tell you to shut up and sit down. I'm sorry, am I to understand that the honorable judge has made a judicial determination that I'm not to be afforded my due process rights of freedom of speech in these proceedings? For the record, ma'am. You kill them. This is how you kill them. You don't have to cuss them out. This is how you kill them, with intelligence, being prepared. What is this? What is this right here? Right here, Sirach 33:4. Prepare your speech, and then you will be heard. Draw up on your training and give your answer. This is in the Apocrypha of the Catholic Bible. Prepare your speech. You think them attorneys is in there talking and they just talking off the top of their head all the time. They got especially the administrative judge. When they come in, you can get you can go and get a bench book and you can see the speech when you're in a foreclosure proceeding. Everything that judge says when he first came in is he memorized it straight out that book. They not coming in there saying stuff off the top of their head. See, when you memorize stuff, when it gets to the point where it's imprinted in your subconscious, that's when you can begin to ad-lib with it. Because now it's a part of you. And now you can play with it, twist it around, use it in different circumstances. But you got to go through the part where you got to memorize it. You have to prepare your speech, and then you will be heard. A security, you say you likely, I don't even know what you mean by a security agreement. They're using security agreements in this process, but not in every process are you going to be using a security agreement. This dude right here, these dudes, they trying to put liens on people. This whole process, that's why I said when they came out redemption manuals and all that, I said it was cool, but I really felt like, man, I don't know, man. This right here, this show people how to lay the groundwork to put liens on motherfuckers and stuff. So I don't know. All right, so here courts and attorneys that ignore the Federal Fair Debt Collection Practices Act requirements to validate. This issue cannot be addressed in this manual because neither we nor the publisher are licensed to practice law, and accordingly, we do not give legal advice. However, if you run into a particularly sticky situation, the publisher may be able to recommend a consultant that can assist you. And that is, they will ignore things all the time. You have to be prepared for that. You have to be prepared for what action to take when they ignore you. They do it all the time because they feel like, man, fuck it, he don't know what to do. You gotta be, let me tell you, you cannot make idle threats. If you say you're gonna sue somebody, if you say you're gonna sue somebody in 10 days, sue their ass in 10 days, because that's what they're gonna do to you. If you say, I'm going to be seeking $2 million from you in damages, God damn it, you do a lawsuit for $2 million in damages seeking it. Don't make any idle threats. If you're not prepared to go all the way, don't start. All right, preparing your package for transmittal, copyright notations. Please always consult sample filings for proper display of the copyright notation for both the true name. This is one you see back in the old school. We used to put our copyright symbol by name. They don't do that no more, but you used to see this everywhere, like in early 2000. Everybody's paperwork, they would say, the copyright, they copyright your name. Each time either name appears within the documents, it should be qualified with one of the following. This is another reason why I think they came out with some of the other books too, to kind of take people away from this, because this right here was the truth. And and that's why I'm always talking about this book, because this book, I'm like, why would you throw this book away? This book still got a lot of information in it. It's old information. When they be talking about that old information, nigga, shut the fuck up. Ain't no old information. You just trying to sell something new. Principles never change. Talking about that old information. As soon as I hear that shit, I know I'm dealing with somebody trying to sell you some shit. Constitution ain't changed. It still ain't no money. There's still a public and a private. We're still talking about equity. You still have to have clean hands and act in good faith. What's changed? I'm not saying that you can't use a new process either. There are many different things you can use. I'm not trying to discount anybody's process. But I don't like motherfuckers who, and especially people, they ain't even read none of the shit. This motherfucker saying that's old information. Bitch, you ain't read it. I know you ain't read it. Home of TE Academy, thank you for the $9.99, bro. I appreciate you. All right, so the quotation marks, true name, trade name, all this is how to sign your name. We're going to go through the section, how to sign your name without liability. So I'm going to skip over all of this. Attachments. The sample documents indicate which other documents get attached. Basically, it looks like this. And it tell you how they're going to put everything together. I'm not going to read this. Okay. All right, let's look at this right here. Let's get into this. This is going to be very, very interesting right here. This is an interesting section. This section is kind of like the section with the car. This is something that is going to stay with you for the rest of your life. I still use this to this day. This is dealing with people who call you on the phone. So pull up a chair and we're going to listen to this. All right. This is a very, very good chapter. How to deal with former creditors after paying by a promissory note. Typical responses. There are a couple of typical responses that former creditors will give upon receiving a certified promissory note within the 14-page administrative remedy demand. Number one, they'll give you a congratulatory letter for paying off the loan. You hope you get one of those. And number two, you're going to get an urgent phone call, phone messages, or correspondence asserting, demanding, or pleading that you call and speak to them immediately. And this is, their fear is verification that you did the right thing. Sir, we really need to talk to you. I got your information. I'm not sure what you want me to do with it. We don't take the thing that they can't say is we don't take this kind of payment. As soon as they say this, fire their ass up. I'm sorry, but am I to understand you're willfully violating public policy? Because it's my understanding that no one can force anyone to pay a debt with any particular species of currency. Is that not correct? No, I don't believe that's correct. Well, could you cite your authority for that statement that you just made? Because I can give you HR 192 of June 5th, 1933, Public Law 73-10, and all associated policies, as well as Title 31, 5118, which is the rescission of the gold clause, as well as the Constitution for the United States of America. The Federal Reserve does not belong to our country. The Federal Reserve doesn't fall under the Constitution. The Constitution did not give permission for the Federal Reserve to circulate currency in our country. That was done through the legislature, but by using some loophole in Article 1, Section 8, Clause 17, because they have territorial jurisdiction. They have plenary power over everything that's in their territory. So they can do whatever they want in their territory. So they took the Federal Reserve and made an act out of it and put it in their territory. Once they got it in their territory, they had to find a way to coax you into that territory. And that's when they first, because the Federal Reserve Act happened in 1913. 20 years later, they bankrupt the country. They took them 20 years to figure out, okay, this is what we need to do. We need to take all their money, take all their gold and silver. Then they'll have to come to us. And once they come to us, we'll issue them a number, give them a social security number. We're going to tax them 33% of their labor. This is the scheme. That's the whole scheme. But see, there's always a remedy because of natural law. There's polarity. They always have to provide a remedy. And the remedy is what we're talking about right here. Discharge. There ain't any money. What, you going to take all my gold without any expectation of return of that gold? We didn't give you that gold to keep and not give it back. And if we're going to give you the gold to help save you, a government, wouldn't you agree that it is your duty to pay our debts for us? Because he who has the gold pays. Is that not correct? Am I saying something wrong? Is there an attorney that can tell me I'm saying something wrong? I know the one that'll try. And you're gonna look like a damn fool when you try. You need to stay in your place as a public servant and let the sovereigns have this discussion, because we're the sovereigns. All right, we don't follow you. You're subservient to us. We're not subservient to you. And you need to remember that. This is the United States of America, not the United States. Our country is America. And within America, all the states united together. I don't know what the fuck United States is. Look at this dude there. It said, is apostille the birth certificate sufficient in Cali? Let me tell you something. You on my channel and you don't know that people come in and talk about authenticating a birth certificate. I tell them what a big goddamn fool they are. You don't know that? That you a damn fool coming in here asking me about apostilling a birth certificate? I have to clown you because you keep on asking questions in the chat. So I'm going to clown you. You're asking for it. Okay. We have I'm going to stop and I'm going to talk about this real quick. I'm going to just take 5 minutes to do it, y'all, because this lady, whoever it is, she's asking for it. So I'm going to give it to her. I'm going to give it to her. All right. So now I have a video called Finally the Truth About Minnesota 220. Now, what these idiots don't realize is that we are the ones who put out the birth certificate authentication. They so deluded, they don't even know where it originated from anymore. They keep on saying it, keep on talking about it. We put this out like in 2015, something like that. They keep on, and let me tell you, it's amazing to me how birth certificate authentication has just kept on going, in spite of the fact that people telling you, look, it was some bullshit. But it keep on. It's just, you know why? Because it's easy to do. It's an easy step to take. Yeah, you become the registered owner of your estate. I did a whole research on arrest you. What this came from Minnesota Rule 220. Let me just get this. Minnesota, Rodney Dale class, and another person, I'm not going to talk about them. They the ones who came out with this. All right, this is a rule of practice. This is not a rule of court. This is not a statute. This is not any of these things. That's the first thing. People are so illiterate that they took a rule of practice and they are all around the country acting like it's some kind of law. So let's look at it real quick. The Register of Titles, I want you to read this because this is a test of your intelligence. This is in testing your intelligence. CC pound her. The Register of Titles is authorized to receive for registration of memorials upon any outstanding certificate of title, any official birth certificate pertaining to a registered owner named in said certificate of title, showing the date of birth of said registered owner, providing there is attached to said birth certificate an affidavit of an affiant who states that he or she is familiar with the facts recited, stating that the party named in said birth certificate is the same party as the one of the owners, named in said certificate of title, and that thereafter the register of title shall treat said registered owner as having attained the age of the majority of the age of 18 years of the date of the birth shown by said certificate. Now this motherfucker is in the chat asking some shit. I don't even know where he got that fucking shit from, apostiles and all that shit. See, as stuff starts going, they just start making up shit, adding shit. I'm like, where are y'all getting this shit from? Because you know why they do it? Because everybody forgot where it came from. It's been going so long, people, they talking about birth certificate authentication. You ask them, well, you know where it came? They don't know where it came from. They just heard somebody tell them to do it. And they do it. And they just do it. Let's look at this real quick. What is a general rule of practice? All right, let's look at this real quick. Let's look at this. Here are the general rules of practice for the Minnesota. Now, first of all, this is a rule of practice up in Minnesota. All right, so we have Rule 220. Where is it at? Let me, as you can see, all of this right here, it falls under what? I want you to read this for me. I want you to read this for me. CC pound her. All right. What does that say? That says Minnesota General Rules of Practice for the District Courts with amendments effective January 1st, 2020. What is this for? Registration of land titles. Now, what is this? This is dealing with, I'll tell you what it's dealing with. I'll try to put it in very succinct terms. We're talking about the, it's called the To Minors Act. It's called the Transfer to Minors Act. Uniform Transfer to Minors Act. Now, this is what this is talking about right here, because we're talking about what? We're talking about real estate right now. So all these rules are talking about real estate. So not only do we got birth certificates, we got death certificates, but they'll never tell you about that. What this is for, because I did the research on it, these are the procedures for bringing a birth certificate into court. When you have a birth certificate, you cannot present it as evidence in court without it being authenticated. All right? It has to be authenticated. Just because you got it from Vital Statistics, that doesn't mean anything to the court. They want it authenticated. And the reason why it has to be authenticated is because we're transferring land. Land, okay, somebody who's under 18, they can't enter into a contract. So if you give them land, okay, it's held by a custodian. Grant Cardone did this with his wife, his daughter. The Transfer to Minors Act. You give your daughter some land. She's under 18. She can't enter into a contract, so it's in the possession of a custodian. Once she attains the age of 18, to transfer that land into her name, you got to go to court. They have to have two witnesses. One of the witnesses is a custodian. He's going to provide an affidavit. The other witness is the damn birth certificate. Now they took all of that and changed it into this birth certificate authentication, because you listening to some people that don't know how to read or research. And that, my dear, is why they call us sovereign citizens, because y'all do shit like that. and run around telling people I'm the registered owner, I'm the owner of this, and I'm the owner of that. And I just authenticate my birth certificate, and some kind of way my status changed. Y'all even use the word minor incorrectly. Did everybody get that? I hope nobody else wants to ask me a question in the chat while I'm talking about and teaching what I'm teaching. See, this is what they do at Harvard. See, at Harvard University, if you was at Harvard and you asked a question like that, you'd be ready to check out of Harvard when the professor got through laying your ass out in front of all the students and embarrassing the shit out of you. So let's get back. If you want to know some more about that, all the research that was conducted, you can, and you're interested in birth certificate authentication, finally, the truth about Minnesota Rule 220. I did all the research on it too, because somebody pissed me off. I said, okay, I did all the research on it in about an hour and did the video the next hour and wrote a paper on it too. I wrote a paper on this. I wrote a paper on birth certificate. I don't even write stuff. You don't see articles from me, but I wrote an article on this. I'll put it up in my PDF section so y'all can download it. I'll put it up there so y'all can see the article I wrote. I wrote an article on, but this whole video is I'm reading the article and guiding you through all the research that I conducted. All right, so can I continue uninterrupted? Because there are people who are really interested in what we're talking about. So right now, we are in a section where we are talking about how to deal with former creditors after paying by promissory note. Okay, typical responses. There are a couple of typical responses that former creditors will give upon receiving a certified promissory note within the 14-page administrative remedy demand. Congratulatory letter for paying off the loan and urgent phone calls, phone messages, or correspondence asserting, demanding, or pleading that you call them and speak with them immediately. Form obligation is discharged. People can be tricked and conned into unwittingly reaccepting the obligation if they discuss anything with the creditor once the promissory note has been tendered. And this is when you get into UCC 3-611. This is what they call recontracting. You hear everybody talk about recontracting. The debt is discharged upon tender of the instrument. It matters not if it's accepted or rejected. UCC 3-603B. Let's pause here and let's look at UCC 3-603B. UCC 3-603B. And I want you to use your common sense on this. This is tender of payment. And what it is right here, it says, if tender of a payment of an obligation to pay an instrument is made to a person entitled to enforce the instrument and the tender is refused, there is discharge to the extent of the amount of the tender of the obligation of an endorser or accommodation party having a right of recourse with respect to the obligation to which the tender relates. Why do you think they would put this in here? Why do you think they put this in here? Why do you think they put this in here? They put this in here because there isn't any money. Look, Mr. Carp, the dealership or whatever. There is no money. Federal Reserve notes are promissory notes. Public policy says you cannot require anybody to pay a debt in any particular species of currency. This is why we do a secure party process. So we can form a contract with the Secretary of Treasury because it is a private jurisdiction. You don't want to be uttering instruments in a jurisdiction that you don't have permission to operate in. People do it anyway. Lots of them get arrested. But the reason that is in there, because there isn't any money. If you don't want to take a negotiable instrument, there's nothing else I can give you because there isn't any money. If I do a tender of payment, because we're talking about UCC Article 3, we're talking about negotiable instruments. So if I tendered a negotiable instrument for full satisfaction of an obligation and you refuse it, let me ask, what else can I give you? What else can I give you? What, a credit card? That's credit. That's not payment. What, a Federal Reserve note? That's credit. That's not payment. That's a promise to pay. You just like that because it's easier to negotiate. I get it, but that's not my problem. I'm going to give you some processing instructions, and if you follow them, then you should get the necessary credits in your account to balance the books on your ledgers. It would be real helpful. Let's stop. Let's pause real quick. Let's read. You go over to that PDF downloads on SBC University. And let's look at this right here. This is the affidavit of Walker Todd real quick. This is a case that was in Michigan where someone hired an attorney that worked for the Federal Reserve to come as an expert witness on a mortgage case. So I'm going to end today's lesson reading the first couple of sections of the affidavit of Walker Todd, because it's going to be necessary for you to hear an expert tell you the things that are going to be talked about in Cracking the Code Article 3, because we're talking about discharging things. Thank you, CC Pounder. I appreciate the compliment. So now comes the affiant Walker F. Todd, a citizen of the United States and of the state of Ohio, over the age of 21 years, and declares as follows under penalty of perjury. Notice he did penalty of perjury? That I'm familiar with the promissory note and disbursement request and authorization dated November 23rd, 1999, together sometimes referred to in other documents filed by defendants in this case as the alleged agreement between defendants and plaintiff, but called the note in this affidavit. If called as a witness, I would testify as stated herein. I make this affidavit based on my personal knowledge of the legal, economic, and historical principles stated herein. Notice the first thing he started talking about is principles. Not methodology, principles. Except that I have relied entirely on documents provided to me, including the note, regarding certain facts at issue. We have facts at issue in this case, of which I previously had no direct and personal knowledge. I'm making this affidavit based on my experience and expertise as an attorney, economist, research writer, and teacher. I'm competent to make the following statements. Professional background. All right, let's see if this man qualifies to be an expert witness. My qualifications as an expert witness in monetary and banking instruments are as follows. For 20 years, I worked as an attorney and legal officer for the legal departments of the Federal Reserve Banks of New York and Cleveland. Among other things, I was assigned responsibility for questions involving both novel and routine notes, bonds, bankers' acceptances, securities, and other financial instruments in connection with my work for the Reserve Bank's discount windows and parts of the open market trading desk function in New York. In addition, for 9 years, I worked as an economic research officer at the Federal Reserve Bank of Cleveland. I became one of the Federal Reserve System's recognized experts on the legal history of central banking and the pledging of notes, bonds, and other financial instruments, and at the discount window to enable the Federal Reserve to make advances of credit that became or could become money. So this credit is money. They're issuing credit. That's what promissory notes are. Promissory notes are credit. It's just like my man, who's my man, JP Morgan. He said only gold and silver is money. Everything else is credit. That's why, let me tell you, with my jewelry, I buy diamonds and stuff, but I concentrate on buying gold because I know diamonds are worthless. Diamonds are worth, and anybody if you don't believe me, just take it to the pawn shop and let them tell you. You can keep those. Can we get the gold? I just paid $25,000 for this. Yeah. Well, we want to get that going. Why they ain't got no trading no diamonds on the commodities market? You know, if diamonds so valuable, why it's not a commodity? What? Why we can't? It can't. Why they ain't backing, you know, money with diamonds? I mean, look, you can't break them. They're one of the hardest substances on the planet. Why? You know why? Because they're plentiful. They artificially restrict diamonds. They got warehouses of diamonds. Why do you think these diamonds keep appearing in all these jewelry stores? Something is only valuable when when there's not a lot of it. So I concentrate on gold. They tricked us in the hip hop world when they had us buying platinum. You ain't heard no king in history trying to get platinum. All the kings want gold. The countries do business with each other in gold. They do business in gold. Everything is gold, man. You understand kings, man? King, he got all the gold, you know. Who has all the gold? Leprechauns. Them niggas won't go. Try to hand a leprechaun to Federal Reserve. It's the gold, man. The gold. They do lab grow diamonds now. They lab grow them. I don't know why they lab grow them, because there's plenty of them. That's just a waste of time. That's just a waste of time too, you know. They're not biblically precious stones. I'm just telling you. I never see we buy diamond shops. Exactly. I'm trying to tell you, I'm trying to get y'all game. Don't get caught up with those diamonds. They look good. Don't get me wrong. That was all a marketing ploy that diamonds are a girl's best friend that they had like in the 30s or 40s or something like that. They marketed all those diamonds onto everyone and started charging a lot of money for them. That's why they like to ice out stuff, because when they ice out something, they can artificially inflate it. That's why when you go in the jewelry store, especially if you're black, they're trying to direct you something with some diamonds in it, not just gold. I don't do anything under 14K either. I don't do anything under 14K. I'm from the old school. From the old school, you had 10K. We looked at that as fake gold. We did. In the new school, that's okay with it. But in the old school, I'm from the old school. We didn't buy no 10K. It was 14K and up, you know. And diamonds, we like diamonds too. I like diamonds. I think diamonds are beautiful. I think diamonds accent gold beautifully. However, when you are negotiating your price on something to buy, you need to always keep that in mind, and that this is not worth me paying $100,000 for this. Whereas if it didn't have no diamonds in it, it'd probably only be about $10,000 or $20,000. That's what you got to be mindful of. That's the game that's being played. 10K, okay, you know, I'm 10K. Some people, you know, they 10K, you know, that what they did was they took all the 14K away from everybody, got everybody to buy it out when they brought in platinum. They got all the rappers to start wearing platinum. Y'all start giving all your gold away. And then when they got through taking all the gold, they brought it back out and they gave you 10K. And now if you want the 14K, you gotta pay some serious bread for 14K now. You got to pay serious bread for 14. They keep 14K in the back and shit like that, or in special section, you know, or something like, oh, you got to go to a real gold, some serious dealer, you know, to get it or something. But the majority of places in the mall, they got 10K shit. $22K gold is too soft. That shit gonna break. Is that, yeah, man gay is 22K, but you know, you can't wear 22K. 18K is cool, but I don't like the way it look. I think 14K looks good. It's that perfect balance. You know, so what, it's like 70% gold or something like that. Yeah, you know. All right, y'all, let's keep going. Let me finish this. All right, because so let's read his professional background qualifications. My qualifications as an expert witness in monetary and banking instruments are as follows. For 20 years, I worked as an attorney and legal officer for the legal departments of the Federal Reserve Banks of New York and Cleveland. Among other things, I was assigned responsibility for questions involving both novel and routine notes, bonds, bankers, acceptances, securities, and other financial instruments in connection with my work for the Reserve's discount window as part of the open market trading desk functions in New York. In addition, for 9 years, I worked as an economic research officer at the Federal Reserve Bank of Cleveland. I became one of the Federal Reserve System's recognized experts on the legal history of central banking and the pledging of notes, bonds, and other financial instruments at the discount window to enable the Federal Reserve to make advances of credit that became or could become money. I also have read extensively treatises on the legal and financial history of money and banking and have published several articles covering all the subjects just mentioned. I have served as an expert witness in several trials involving banking practices and monetary instruments. A summary biographical sketch and resume, including further details of my work experience, readings, publications, and education, will be tendered to defendants and may be made available to the court and to the plaintiff's counsel upon request. Now we're going to talk about GAAP real quick. The first thing this expert witness starts talking about is generally accepted accounting principles, because we're talking about money of account. So if you're going to understand what is going on behind the scenes, you got to understand some basic accounting. And you have to also understand that they're required to use GAAP. The requirement to use GAAP is very important, especially when you're trying to enforce something that you're setting off. You need to understand how they conduct the accounting in order to substantiate your position. This is what gives you confidence that you're doing the right thing. So before we get into that, let's go to, I forgot what chapter it is. This is United States Code, GAAP. What is it? It's in, oh, I put, yes, it's right here. I want you to write this down. 12 U.S.C. 1831N, Accounting Objectives, Standards, and Requirements. So right here, this is under 2. It says, subject to the requirements of this chapter and any other provisions of federal law, the accounting principles applicable to reports and statements required to be filed with federal banking agencies by all insured depository institutions shall be uniform and consistent with generally accepted accounting principles. So they're required to use GAAP. Okay? So you need to understand that's where it is in the federal law. You know, if you need to quote it, according to, Title 12, United States Code, subsection 1831N, paragraph 2, A2, you're required to use generally accepted accounting principles. Is that not correct? So once we do that, now we get into a discussion about the matching principle. Write that down, the matching principle. The matching principle. That's why it's important. So, right here, let's get in there. Banks are required to adhere to generally accepted accounting principles, GAAP. GAAP follows an accounting convention that lies at the heart of the double entry bookkeeping system called the matching principle. This principle works as follows. When a bank accepts bullion, coin, currency, checks, drafts, promissory notes, or any other similar instruments, hereinafter instruments, from customers and deposits or records the instrument as assets, it must record offsetting liabilities that match the assets that it accepted from customers. The liabilities represent the amounts that the bank owes the customers, funds accepted from the customers. In a fractional reserve banking system like the United States banking system, most of the funds advanced to borrowers, assets of the banks, are created by the banks themselves and are not merely transferred from one set of depositors to another set of borrowers. Now, this is a very important paragraph for you to understand if you're going to talk about discharging debt. You got to understand generally accepted accounting principles. Why? Because you got to know that when you get a deposit, I want y'all to think about this. Think. I'm going to put it in layman's terms. Look at a Federal Reserve note. Look at a $100 bill, a $50 bill, a $20 bill, 5 or 1. If you have it in your pocket, pull it out now and look at it if you have access to one. I want you to look at the top and see where it says note. When you take that to the bank and make a deposit, you are depositing a promissory note. The bank is going to record it as an asset. However, simultaneously, they're going to record it as a liability. How can it be an asset and a liability at the same time? Well, it's an asset because now they are the holder of it, and they're going to use it, monetize it, and do something with it. But they're liable for it because they have to give it back to you. And they usually give it back to you when you come in and ask for withdrawal, or you use your credit card or your debit card or something like that. So at the same time, it's an asset and a liability. So it has to be recorded on their sheets as such. Now, I want you to take that same principle and apply it to when you buy a house. You're at a table. It is called a financial institution. Write this down. Write this down. What's the definition? No, I think the definition of financial is, it's, what is it? Not CFR, it's United States Code. Yeah, this is it right here, 5312. Write this down, 31 USC 5312. So you can see right here, this tells you what a financial institution is. An insured bank, a commercial bank, a trust company, a private banker, an agency or branch of a foreign bank in the United States, any credit union, any thrift institution, a broker or dealer registered with the Securities and Exchange Commission under the Securities Exchange Act of 1934, a broker, a dealer in securities or commodities, an investment bank or investment company, a currency exchange, an issuer, redeemer, or cashier of traveler's checks, money orders, or similar instruments, an operator of a credit card system. Damn, I operate one of those, so I'm a bank, I'm a financial institution. An insurance company is a financial institution. A dealer in precious metals, stones, or jewels is a financial institution. A pawnbroker is a financial institution. A loan or finance company is a financial institution. A travel agency is a financial institution. A licensed sender of money or any other person who engages as a business in the transmission of funds, including any person who engages as a business in an informal money transfer system or any network of people who engages as a business in facilitating the transfer of money domestically or internationally outside of the conventional financial institution system. A telegraph company is a financial institution. A business engaged in vehicle sales, including automobiles, airplanes, and boat sales, is a financial institution. Persons involved in real estate closings. You a person. Persons involved in real estate closings are financial institutions. United States Postal Service is a financial institution. They issue money orders. All right. So, but what I want you to pay attention is to you. You are a person who's involved in a real estate, in a financial institution. You're in a real estate closing, and you have a promissory note at the table, and you're making a deposit. The matching principle applies. They have to put that on their books as an asset and simultaneously put it on as a liability. But that's why they give you a mortgage. They give you a mortgage where you promise to pay it back over 30 years. And then in that mortgage contract, you will see verbiage that talking about that you guarantee that the property is seized. It comes from the word CHISOLM, which is it comes from a feudal time in England. However, what you're saying is that you own the property. So you signing a piece of paper that say you own the property, and you're taking a loan on the property that you already own. I brought that to an attorney's attention. He told me, he said, yeah, you're absolutely correct, but they're not going to let you bring that into court. He said, they're not going to let you bring that into court. I was like, word? Man, y'all don't know all the fraud that go on with real estate. Boy, let me tell you. Man, that's number two behind the criminal justice system. Right? To me, behind the criminal justice system as far as corruption is the real estate, because the banks are dealing in it. And let me tell you something, the banks own the court system. Listen to me, the banks own the courts. They're not going to admit that, but they own the courts. They own the courts. They can make phone calls and make shit happen. It's like that. It's that type of level. And I'm saying that with absolute certainty and no problem saying it. So they financial institutions. So you're at a closing, which is a financial institution, signing a promissory note that they're going to stamp paid to the order of. I hope you know that. And they're going to deposit it as funds. You paid for the property. This is why you have a right of discharge. This all... Man, let me tell you, when you start getting into studying securities, that's another interesting topic that you may want to explore and start studying so you can understand how they bundle these securities and the rights that are afforded to different parties that are involved with the securities transaction. That's something that you need to start looking into too. I might do a little short thing on that too. But let's go back. Let me. I don't want to digress too much. I just wanted you to see that. Okay, that promissory note is a negotiable instrument, but they treating it like a check. So right here, so he's going to talk about relevant distinctions of money. This is important for you to understand too, the different types of money that there are. You got to understand, and how people get things confused. See, in order for you to be a creditor and discharge, you got to have be firm in your mind exactly what a Federal Reserve note is, what real money is. You know, you got to have that firmly etched in your mind, because people have become so accustomed of using Federal Reserve notes, we just all think that's money. We don't even question it anymore. And to start questioning it, it makes us feel funny because it seems like we're going against money. You know, it makes you feel funny. You know, it makes me feel funny because, you know, I try to get as many Federal Reserve notes as I can. I'm not going to lie. I try to get as many as I can. But at the end of the day, I'm trying to convert it into assets too. Because it's just like Robert Kiyosaki, he didn't lie. That money ain't worth shit. The fact, when you get Federal Reserve notes, the only reason that they're worth anything because you can convert them into an asset. And the faster that you can convert it into an asset, the better. That's why you want them. You don't want to get them to stunt, nigga. You're trying to get them so you can money change them into an asset, like real estate, apartment complexes, houses. You're going to convert that shit as soon as you get it. That's why them dudes be saying they stay broke. They say that them investors, you know, like Grant Hill say that, you say stay broke. What that means is invest everything. Invest every dime to come into your hand. Because what that paper ain't worth shit. It ain't worth shit. That's how you do it. You don't do it just walking around saying, fuck money. Yusuf, ain't really no Federal Reserve notes, ain't really no money. And saying that old motherfucking lame shit because you can't make money. Because the only people who talk like that is people who can't make money. And if you can't make money without money, you can't make money with money. Because money is made in the mind. Wealth is a mental sport. That's all you saying is you don't want to get on the playing field and play the game. That's too much. I gotta think too hard, Yusuf. That's what you're saying to me. They get mad at me. Why you charge? Man, look, Federal Reserve notes is just a medium of exchange. All right, but you need to know what to exchange it into. It's the medium, it's the in-between. So you're trying to get hard assets, because when you get the assets, it doesn't matter what the money is, because whatever they convert the money into, that's going to be utilized to obtain goods and services, and you're on the side where you're providing goods and services. So they got to give you whatever they start using. You're going to be a recipient of that. It doesn't matter what the money converts into, whether it's Federal Reserve notes, gold, silver, marbles. People with assets don't give a fuck. It's the people who don't have the assets worried. The same stuff that was valuable even in biblical times is valuable today. Cattle, livestock, crops, land, natural resources, the same stuff that made people wealthy 10,000 years ago is the same shit that make people wealthy today. Ain't shit changed. You better change the way you're thinking. Because they trying to snatch up all the land and they programming you right now. You will own nothing and you will love it. That's a goddamn, this sound like that's some type of, they trying to hypnotize somebody. You will own nothing and you will love it. You will own nothing and you will love it. When you awake from this hypnosis, you will own nothing and you will love it. Hypnotizing motherfuckers with that. Y'all know that's what they're doing, right? They think people stupid. I'm trying to tell you. Listen, man, they think, this is why I do this, y'all. Because they think everybody's stupid. And then when I look out into the world, I see they writing shit. It's not that you're stupid, it's you distracted with bullshit. And then when you come, you try to show people stuff. It's like you get all this resistance and lazy people and, everything like that. You trying to force motherfuckers, to the water and everything. It's like, that's the thing, but I'm just here, I've gotten to the point, all I'm going to do is tell you, this is what it is. All right, you need to understand it. That's what it is, okay? Federal Reserve notes is not what you want. You're absolutely right. They're not worth anything, but you're accumulating them to convert them into assets. It's just the medium of exchange that's being used. And you want to do it fast as you can before everybody wake up. Because as soon as everybody wake up that they really ain't worth nothing, then that's when they're not going to be worth nothing. The only reason they worth anything because you can find somebody else that'll take them. Man, this should be funny. Y'all know y'all think I'm probably crazy, but when you really just see the game that's being played, it's funny. It's like, who thought of this shit? It's like a mad, you have to respect it, but it's like, when you really see, like, you have to say, how did I fall for that shit? Oh, man. It only hurts when I laugh. Yeah, I'm trying to tell you. Let's finish reading this real quick. This talking about different kinds of money. So this is necessary for you to know if you're going to be discharging debt. You need to understand this section right here. You shouldn't be, if you're discharging a debt and the things I'm talking about you don't know, that's why people can come and make you look like a fool. Because you don't have basic understanding and principles behind what you're attempting to do. So, relevance of subtle distinctions about types of money. From my study of historical and economic writings on the subject, I conclude that a common misconception about the nature of money unfortunately has been perpetuated in the U.S. monetary and banking systems, especially since the 1930s. In classical economic theory, once economic exchange has moved beyond the barter stage, there are two types of money of exchange and money of account. For nearly 300 years in both Europe and the United States, confusion about the distinctiveness of these two concepts has led to persistent attempts to treat money of account as the equivalent of money of exchange. That is what everybody's out there doing. Trying to treat money of account as the same as money of exchange. They're not the same. They're not the same. You can buy anything with Federal Reserve notes because it can be exchanged. It's not gold. People don't care about gold either. People only care about what gold can get for them. People don't really care about gold. That's how they got all the gold in the first place. Because we took a gold and let them hold it for us and then start using gold certificates instead of the actual gold. And that's how we got into this mess. People don't care about gold. They only care about what gold can get them. No, listen, man. You didn't bring nothing here. You don't really own nothing in this world. Nobody does. That's an illusion too. Because you came here with nothing and you're leaving with nothing. You only using stuff while you're here. So everything that you own, somebody else is going to have. Somebody else is going to be driving that car. Somebody else is going to be wearing that jewelry. Somebody else is going to be living in that house. That's a reality. That's a reality. So understand, that's why trust is important. Because, you want to bequeath property, to your children or something like that. That is an excellent vehicle to do it with. And that's why that's what you really want. You don't want to own anything. You want to control everything because you can't really own it anyway. So that's why they say own nothing but control everything. You can't really own anything, but you can control it, and you can control it down for generations to come. That's all you're doing is controlling assets for the benefit of your family for generations to come. But you don't really want to own it. You just want to control the energy flow of it. It's the energy flow. And you want to stay in control of that energy flow. Because money is really energy. It is the attracting, it's the ability to accumulate massive forms of energy that can be directed in a certain direction. And you have to attract that to you. And you attract it to you by thinking about it all the time. Anyway, let me keep going. Let's keep going. So down to the barter stages, is when we used to, wasn't no medium of exchange. We just, you give me some oranges, I give you some apples, that type of thing. So we only have money of exchange. There's two types of money of exchange and money of account. And this is important for you to know. You need to understand what is the distinctive difference. Money of exchange is gold or silver or certificates that are redeemable in gold or silver. Those are the only things that can be considered real money. They try to call this other stuff money, but it's just money of account. It's an accounting that's going on. They're just keeping track of who owes who what. Because everything is operating in a world where everybody making promises. So remember, money is energy. That was told to me when I very first came into this information. And it hit me when it was first said to me. Hakeem, you said that to me, brother. If you're listening, you're the one who first said that to me, man. I'll give you your flowers. When I first gave me this book, gave me a Black's Law Dictionary, and as soon as we started talking about money, he said, money's energy. And he said, you were absolutely correct. Money is energy. Money is the effect of a certain way of thinking. That's the only reason people can't come out of poverty, because they refuse to change the way they think. They refuse to. They don't believe that if they change the way that they think, that their circumstances will change. And they can't believe it's that easy. Or they're too lazy or lethargic thinking to even put in the effort to do it, because it is a habit that you have to break. Poverty is a habit. It's a habit you have to break. It's a way of thinking. You got to stop saying, I can't afford that. You got to strip that from your vocabulary. You got to replace that with, how can I make this happen? How can I acquire that? By asking yourself a question and forcing your mind to think, instead of just being dismissive and shutting down. I can't afford that. Telling your children, we can't afford that. You passing the disease on to them. Stop saying that. Strip that from your vocabulary. Strip that from as soon as something come in your mind where you start to doubt yourself, that's what affirmations are for. I always say, I'm whole, perfect, strong, powerful, loving, harmonious, and happy. I'm whole, perfect, strong, powerful, loving, harmonious, and happy. I just start saying some type of affirmation to myself to kill it, to stamp it out. You got to stand. That's the whole goal in life. The goal in life is to train yourself to be positive at all times. And then only positive things will come to you. That's how you become happy. But it requires effort. It requires effort. It's just not given to you. Like getting in shape. You can't get in shape. You can't pray to God to get in shape. You got to go out there and run them miles. Restrict that diet. It ain't magically happening. It's something that you have to earn. You got to earn it. So so we're talking about money. We're talking about money of exchange and money of account. And this is expert witness, Walker Todd. He said, in reality, especially in a fractional reserve banking system, a comparatively small amount of money of exchange, namely gold, silver, and official currency notes, may support a vastly larger quantity of business transactions denominated in money of account. That's where that 10% reserve is coming from. That 10% reserve is coming from in history, when they used to get gold, like they go up into the mountains and get the gold. Eureka! And then they put the gold and put it over their shoulder and walk back down the mountain. There'd be somebody down there waiting with a building, because carrying that much gold is not only cumbersome, but it's also dangerous. You could get robbed. So they had a building that they took it to with bars on it and guards, and they would weigh it up, and then they would give you a certificate for the amount of gold that you gave them that you could bring back and redeem, and they would give you the gold back. However, they start getting so much gold and people start getting the certificates, and instead of redeeming them to get their gold back, they start exchanging them for goods and services. Hey man, you see that horse you got? Here, I got a gold certificate. You can go over there to that building and get the gold and just let me have the horse. And then the dude would do it, but he wouldn't get the gold. He'd go buy a wagon. And that's how it starts circulating as currency. And so the bankers, they saw, nobody's coming to get the gold. But some did come back to get their gold. Only 10%, only 1 out of 10 people actually went back to try to get their gold. And they understood, as long as they kept enough gold on hand to show the public that if they come to get their gold, there's some here for them, that they can loan out 10 times the amount of the gold that they actually have on hand. This is fractional reserve lending. That's very significant. This is why when they had a run on the bank, a run on the bank would kill it. That's why they had to rescind the gold clause. So now ain't gonna be no runs on no bank. They could just keep printing paper money. They just print it on a printing press now. There's no money or substance backing nothing. That's what HJR 192, June 5th, 1933, Public Law 72-10 was all about. They removed our ability to come redeem our gold. But the government had to make a promise. They had to give something in return for us to accept that. And that's where the discharge process is coming from. Their irresponsibility putting the country in debt like this. When you read the I read the congressional record, which is number 672, I think, of HJR 192. I was reading what them senators was saying. They was in there. They was saying you didn't have to go to the Federal Reserve and borrow no money. You could have went to the people, but you chose not. No, I think that was in Silent Weapons for Quiet Wars. He was saying that. He was saying they didn't have to come to us to get any loans. They could have went to their own people, but they didn't. They didn't have they shouldn't have dealt with them people at all. The United States was the wealthiest country on the planet. Now it's the one that's most in debt. They done ran this country into the ground. I traveled around Europe and everything. The airports, everything is so much nicer over there than over here. I'm like, damn, we ain't invested into the infrastructure of our country like we should be. We like one of the last ones to get the phones with the video, like what y'all doing with the FaceTime and all that. We were the last ones to get all that shit. So understand what money is, and that they using now just paper that's not backed by anything, but the confidence that you can get a piece of paper and give it to somebody else, and because they recognize it, because they're familiar with it, they will accept it. And because all your grocery stores are licensed from the state and they all in the Federal Reserve System, and these are member banks of that system. It's a club. It operates, and they gave you a membership card to come in and accept the benefit of being able to use use the Federal Reserve System, they gave you a Social Security card. That's just like a Sam's Club card. You can't shop in Sam's Club and get nothing without that card. You can't go get no benefits and privileges from the federal government without that card. Now you need to go and find out everything that constitutes a benefit and a privilege. Because there's a lot of people think they got rights to shit when it's just a benefit and a privilege. That's when you're going to start seeing the difference between a conservative and a liberal. A liberal is a person that really don't believe in doing things for himself. He believes in having the government doing for him. A conservative believes in doing things for yourself and being held accountable for things that you do. That's the fundamental difference between the two platforms. One is for welfare. They want the government to do things for them. They want the government to regulate activity. Like, no. We don't want the government involved in our business. This is a free country. That's how the country was developed. This is a constitutional republic. It is not a democracy. The democracy resides within the 10-mile square in Washington, D.C. The word democracy is not in the Constitution for the United States of America. It wasn't mentioned in the Declaration of Independence. I don't make a pledge to a democracy. I make a pledge to a flag for a republic for which it stands. These differences, y'all gotta get a little swifter with understanding basic civics. Basic civics. I mean, the civics is so bad in this country. People be arguing over political matters, and the only reason they have the positions that they have is they so ignorant about civics. They don't know how their government is put together. They be blaming the president for shit. The president don't make laws. The most powerful branch of government is Congress. They the ones that can declare war. President can't declare war. They make all the laws. The president just signs them. And if he don't want to sign it, they go back, get 2/3 of the people together and pass it anyway. People need to get back to their basic civics again, because that's a problem, because that's why people, you have that political position because you're ignorant about the civics of the country. You're ignorant about the history of the country. You're ignorant about the history of your political platform. You will say that the Democratic Party are not socialists, but then if I asked you to explain socialism to me or Marxism, you wouldn't be able to do it. If I asked you, have you read the Communist Manifesto, you wouldn't be able to do it. So you don't know if it's not socialism or Marxism. You don't know that. They are betting on that you won't ever read. They count on that shit. They operate because they know the vast majority of people are too busy in their lives with distractions and everything to ever do something as simple as just read the Constitution. Let me keep going, man. What time is it? Damn, I went past my time. All right, y'all, look, I'm gonna end it right here. We're gonna come back tomorrow. And, let me do this. I'm gonna read this section right here. I'm gonna read this section. Right here. I'll start right here. For nearly 300 years in both Europe and the United States, confusion about the distinctiveness of these two concepts has led to persistent attempts to treat money of account as the equivalent of money of exchange. In reality, especially in a financial reserve banking system, a comparatively small amount of money of exchange, namely gold, silver, and official currency notes, may support a vastly larger quantity of business transactions denominated in money of account. The sum of these transactions is the sum of the credit extensions in the economy. And then you got to understand, well, where are they extending credit? Extension of credit is they extending it from the private into the public. The credit is coming from us. With the exception of customary stores of value like gold and silver, the monetary base of the economy is largely consists of credit instruments. Against this background, I conclude that the note, despite some language about lawful money explained below, clearly contemplates both disbursement of funds and eventual repayment of settlement in money of account. that is, money of exchange, would be welcome, but is not required to repay or settle the note. So we don't need money of exchange. The factual basis of this conclusion is the reference in the disbursement request and authorization to repayment of $95,905.16 to Michigan National Bank from the proceeds of the note. That was an exchange of credit of Bank One plaintiff for credit apparently and previously extended to defendants of Michigan National Bank. Also, there's no reason to believe that plaintiff would refuse a substitution of credit of another bank or banker as complete payment of the defendant's repayment obligation under the note. This is a case about exchanges of money of account, credit, and not exchanges of money of exchange, lawful money, or even legal tender. Ironically, the note explicitly refers to repayment in lawful money of the United States of America. You'll see that in y'all contracts. See promise to pay clause. Now he finna explain how this is he really saying he don't know why they put this in there. Watch. Traditionally and legally, Congress defines the phrase lawful money for the United States. Congress defines what that is. Traditionally and legally, Congress defines what is lawful money of the United States. Lawful money was the form of money of exchange that the federal government or any state could be required by statute to receive in payment of taxes or other debts. Traditionally, as defined by Congress, lawful money only included gold, silver, and currency notes redeemable for gold or silver on demand. In a banking law context, lawful money was only those forms of money of exchange, the forms just mentioned, plus U.S. bonds and notes redeemable for gold. Remember I talked about gold certificates that constituted the reserves of a national bank prior to 1913, date of the creation of the Federal Reserve Bank. See lawful money. He said, in light of these facts, I conclude that plaintiff and defendant exchanged reciprocal credits involving money of account and not money of exchange. No lawful money was or probably ever would be dispersed on either side in the covered transactions. This conclusion also is consistent with the bookkeeping entries that underlie the loan account in dispute in the present case. He talked about the bookkeeping entries. You got to get somebody who can audit the books. Moreover, it is puzzling why plaintiff will retain the archaic language, lawful money of the United States of America, in its otherwise modern-seeming note. It is possible that this language is merely a legacy from the pre-1933 era. Modern credit agreements might include repayment language such as repayment obligation under this agreement shall continue until payment is received in fully and finally collected funds, which avoids the entire question of in what form of money or credit is the repayment obligation due. And the reason why he's saying this is because they can't ask you that because there ain't no money of account. You can't require me to pay something in any particular species of currency. That's what he's saying. So they verbiage that they have in that contract by what he's saying right here could get them possibly in trouble if they run across the right person. Legal tender, a related concept, but one that is economically inferior to lawful money because it allows payment in instruments that cannot be redeemed for gold or silver on demand, has been the form of money of exchange commonly used in the United States since 1933, when domestic private gold transactions were suspended until 1974. Domestic private gold transactions, that's you. Basically, a legal tender is whatever the government says it is. The most common form of legal tender today is Federal Reserve notes, which by law cannot be redeemed for gold since 1934 or since 1964 for silver. See 31 United States Code section 5103 and 5118B and 5119A. They can't be redeemed. I'm gonna stop right there, and we gonna continue. I wanted to kind of prime your appetite or kind of whet your appetite for this document, and maybe y'all have a study group, because this is the type of document y'all should have a study group on and painfully and painstakingly go through the entire document, looking up every word you don't know the definition of, and then cross-referencing all the United States codes that are pulled up and actually reading them. Not just reading 5103, you actually stop and go to 31 USC 5103 and read what's over there. That's how you become good at this, by taking the time to do the work to allow stuff off of a page to gloss over your eyes, to fall over your eyes. Because believe it or not, you may not think you retain things, but you're retaining something. It doesn't matter if you don't understand it. When you keep reading it over and over, the brain cells, the secret to intelligence is that people who give up on things, that's why they're the least intelligent, because they give up too quick. A lot of people don't understand something the first time they read it. But when you keep reading it over and over and over again, brain cells begin to form in your brain, and then they align in such a way that now your mind becomes receptive to the information, and that's when you have an aha moment. And then you understand what it is that you're reading. But that it requires repetition. That's why they say repetition is the key to learning. It's repetition. Because that's how the brain works. You know, college is to learn how your brain works. They're supposed to be giving you exercises so you understand how your brain works. You understand how to commit something to memory. You understand, like for me, it was just reading aloud. Helped me just, for some reason, it just helped me with my comprehension than just reading it quietly. It was just something about that. But yeah, it is. It's called consolidation, the connection between the two neuronal ends. Yeah. Yes. So, so it's like, that's how, once you understand that's how your comprehension and learning is acquired, then you'll know, okay, I know I don't understand this right now, but if I keep doing it, I can't tell you how much money I've made in doing things where I was about to give up and I kept going because I about to give up because I didn't understand what I was doing. And then I said, man, I'm not going to give up. And then just because I said I'm not going to give up, the very next push, bam, it was right there. And all of a sudden I understood what I was doing and end up making a lot of money. It's happened, it happens. You can't give up. That's why persistence is one of the key elements in success. It's a definite chief aim and persistence. Intelligence has nothing to do with acquiring wealth. It's a definite chief aim, because there are dumb people who are wealthy and smart people who are wealthy. There are fat people who are wealthy, skinny people who are wealthy, people who came out the projects who are wealthy, people who came from rich people, a rich background. It don't have anything to do with any of those things. It's the only thing, the common denominator with all those people is they knew how to think. They had a definite chief aim and they were not going to give up. Because that persistence is key. All right, y'all, I'm going to end it on that. I want to thank everybody for the donations. I appreciate you. I will be back tomorrow at the same time. We'll go through this again. Hopefully you gleaned some nuggets, some valuable nuggets of truth and whatever it is that you need from listening to these broadcasts. I welcome your comments under the video. Let me know if you're enjoying this or you're not enjoying this, and tell me why. I say, yeah, I really like when you do X, Y, and Z, blah, blah, blah. Make that some of the comments that are under the channel. I really want to hear your feedback on these things that I'm doing, and just let me know what I probably need to change or update, or whatever. It's going to get better. I'm trying to get past this foundational information so we can get into the actual document creation, because I do want to create some documents right in front of your face on the screen, as well as, maybe even construct a negotiable instrument. Copy the one that they got and do some court paperwork and show you how you can do court paperwork on your computer. Well, it looks, exactly like how they draw theirs up. Just things like that, because those are fundamental things. I had to go through all of that, to learn how to, because, you talk about legal paperwork. Well, you got to learn the fundamentals of drafting a legal document, whatever, you got to go through all of that. So some of these documents actually help you go through some of those things too, because the people who are writing them are very learned and they know what they're talking about. So, but it's always good to get something like this. Y'all don't understand how valuable this document is with a Walker Todd. You should have a copy of this every time you discharge a debt and you take it into court. I always have it with me. I always have a copy of this because that's your expert witness. That stops all that vapor money theory shit that they talk about and a lot of other bullshit. So you got to understand how evidence works. So, that's why, and then they're going to always mock you and call you names because you're a pro se litigant coming in there into their territory and you're unlearned. You like a person and going into Japan and going to court and don't nobody in the court speak English and you speaking English and you think you're finna win in court. You trying to represent yourself. Everybody in there speak Japanese. They right when they say a fool has himself for an attorney. A person who has himself an attorney is a fool for representation or something like that. That's a true ass fucking statement. That's a true statement. If he's unlearned, that is a very true statement. All right, let me get up out of here. And I'm gonna get up out of here and I will I'll see y'all tomorrow at the same time. All right, peace to the guys. Like, comment, and subscribe. I'm out. Peace to the guys. I'm out.